I'm Drew Stevenson, and this is a quick video about the Federal Vacancies Reform Act, which is the law of acting directors. Now, I have a separate video that explains the basic idea of acting directors and why they matter, and how a little bit about how they're different from, say, recess appointments. But here we're going to be talking about some of the particulars of the actual statute that governs acting directors. Now, this is part of a larger body of law about presidential appointment powers, which the Constitution, on the one hand, sets some limits on, and on the other hand, seems to kind of spell out what those limits are. And so in an administrative law class, we do usually a whole unit on this because it's one of the ways in which the biggest ways in which the president controls the federal bureaucracy, or the thousands and thousands of people that work for the federal government and do the day-to-day work of governance. So let's go back to our slides. So in the Constitution, we're going to start with the Constitution as a little bit of framework. The Appointments Clause of the Constitution says that the highest level officers in agencies in the United States government should be nominated by the president and then confirmed by the Senate. And as you may remember, if you're in a class, there's also a mention in the Appointments Clause about inferior officers who are kind of these mid-level people that can be appointed by others. But the norm, the top person in an agency is going to be appointed by the president and have to go through Senate confirmation. And sometimes this is easy, sometimes it's perfunctory, but if you have a lot of political tension or brinksmanship between the Senate and the president, let's say they're from different political parties, the Senate might be refusing to confirm the president's nominees or appointees. And so somebody has to take over if a vacancy opens up at the agency. The Vacancies Reform Act applies when an officer in an advice and consent position, that's what we're talking about here, in the executive branch, leaves office or becomes unable to perform their duties. And the place where this is found in terms of the statute, our federal code, is in 5 United States Code, or USC 3345, and the following section 3346 has some additional details like the number of days acting directors can serve and so forth. But most of the heart of the Vacancies Reform Act is right there if you ever need to write about it or research it. So the Vacancies Reform Act applies when an officer in an advice and consent position, as we said, leaves office or becomes unable to perform duties. And it then gives the president sort of 3 options. And the first is what the statute calls the first assistant, which in theory should be the number 2 person at the agency, to the vacant office, will automatically take over. So this is the default rule, and it's certainly okay for the president to just kind of give his or her imprimatur to that. But even if the president doesn't do anything, the number 2 person at the agency will just sort of start filling the role of an acting director when the director leaves. And remember, the director could be a secretary, if it's a cabinet position. Sometimes they're called directors and sometimes they're called administrators. Could also be a commissioner or board member. The president could also appoint someone else instead of that kind of number 2 person or first assistant at the agency. By the way, the statute doesn't really define first assistants, and this has created some confusion for the courts. But the president could also appoint anyone who's currently holding a Senate-confirmed position in the executive branch. So, for example, if the head of the EPA steps down and the president doesn't want the first assistant at the number 2 person at the EPA to take over, the president could, for example, appoint someone from the Securities and Exchange Commission who already went through Senate confirmation to take over, or the head of Housing and Urban Development could instead take over the EPA if the president wants, because that person has already gone through Senate confirmation. Also, a non-Senate confirmed senior employee serving in the same agency as a vacant office who's been there for at least 90 days or 3 months out of the previous 365 days. So let's say again that we had someone at the Environmental Protection Agency, the top person left, and the president wants to skip over the number 2 person at the agency, or maybe they're leaving too, or maybe they have declined the position. They don't want the headache. And so we could go to someone else in that agency who, even though they haven't been confirmed by the Senate, if they've been there for at least 3 months out of the last year. Now, there are some exceptions because other statutes may apply. And for example, this statute does not apply to commissioners of the Federal Energy Regulatory Commission. And remember that, that Congress has the power to just say in another statute for this agency, vacancies should be filled this way, and here's our order of succession for this agency instead of the Federal Vacancies Reform Act applying. So the Federal Vacancies Reform Act is our fallback rule or default rule, but Congress can go ahead and exempt certain agencies and give them a different succession plan. Also, keep in mind that because the FVRA is a statute, a more recently enacted statute can overrule it. And this is kind of a canon of statutory interpretation that typically courts like to work with the assumption that when you have a little bit of a conflict between 2 statutes, like the Federal Vacancies Reform Act and then a agency-specific statute that has a different order of succession, that the more recently enacted one should control in this case, if it's relevant to this case. On the other hand, that doesn't always work. And so sometimes courts have instead insisted on applying the FVRA even when we have a subsequently enacted statute. But it's certainly a plausible argument that a more recently enacted statute that has a different succession plan should apply instead. The FVRA itself allows some pre-existing statutes to overrule it. So it may mention some other statutes if those statutes expressly laid out a different succession plan for an office. And so this is why we're starting to get cases work their way up through the courts about this statute and about acting directors, because the statute itself could be overruled by subsequent statutes, and it also seems to create a grandfather clause if prior statutes have a clear or really explicit succession plan, which most statutes did not. It's a little bit unclear what happens if the FVRA and another statute both authorize a particular person to serve as an acting official, and courts have simply reached different results in similar cases in recent years. And it is also not clear what happens if an agency-specific statute does not give a time limit, but the FVRA does. So if the Federal Vacancy Reform Act says acting directors can only serve for 210 days, which it does, but another statute seems to apply instead, maybe it was enacted subsequently, and it expressly says the Federal Vacancies Reform Act doesn't apply. Instead, this person takes over when the agency head leaves. Well, that's fine, but what if Congress forgot to tell us how long that acting director can serve? Should the courts go back to the Vacancies Reform Act for guidance about that? And again, courts reach different views about this. Now, remember that in the background, we have a system of checks and balances between the branches of government that the Constitution intentionally created. So this is one of those kind of checks. It serves as a check on a president's ability to basically circumvent or ignore Senate confirmation or the advice and the consent of the Senate for high-level officers. And so the recent administration, for example, President Trump, said at one point he liked acting directors. He liked them because he didn't have to deal with the political headaches of going through Senate confirmation and vetting someone. He could just put in a person. They were going to be there a while, and because their position was so kind of attenuated, they might be a little more loyal to the president or just take their marching orders directly from the president instead of having some of their own policy ideas. Now, note that unless an acting officer is serving in compliance with the FVRA, any attempt to perform the functions and duties of that office will have no force or effect. And what we really mean is they won't hold up in court. I mean, you can write orders and bring enforcement actions till you're all you want, but if they're challenged in court, they won't hold up. And I'm going to give a couple of examples that have happened during the Trump administration that really drew a lot of the public attention to the acting director problem for the first time. So the first was his second attorney general, which was an acting attorney general, Matthew Whitaker. Trump's first attorney general was Jeff Sessions. He resigned in November of 2018, and then President Trump invoked the Vacancies Reform Act and designated Sessions' chief of staff, who was Matthew Whitaker, as a temporary acting attorney general. But the problem is that it didn't seem like Whitaker was the first assistant under the statute. And in fact, courts kind of reached different views about this in litigation. The attorney general signs off on a lot of actions, not just litigation, but proposed regulations and things like that. And so questions arose about the timing and appearance and legality of this appointment, and also about Whitaker's political background. One example is Guedes versus ATF from 2020. The Supreme Court ended up kicking it back to the DC Circuit, so it's still going through another phase of litigation, but this was the ban on bump stocks. You may remember that after the Las Vegas massacre, the shooter who had used a contraption called a bump stock to turn his semi-automatic assault rifles into something that's similar to, not exactly like a machine gun. In other words, you can pull the trigger and it will rapid fire repeatedly using the kind of recoil or kickback from the gun itself to pull the trigger again and again and again. Now, technically, it's not as fast as a true machine gun, but if you watch the horrific videos of the massacre, it sounds like a machine gun, right? It's a rat-tat-tat-tat-tat. And so you squeeze the trigger once and it will just continue to spray bullets. And so after that massacre, the alcohol, tobacco and firearms, the Bureau decided to ban bump stocks at the president's direction. And Whitaker and Sessions oversaw most of this rulemaking process for a new bump stock rule that was going to basically say these are, turn a gun into a machine gun, and that puts them under the machine gun statute, which is not called that, but there's a federal statute that basically bans machine guns and from production. But what Sessions left before the rule had been formally published and promulgated through notice and comment rulemaking. So acting AG Whitaker actually signed the final bump stock rule. And this was, of course, challenged by Second Amendment advocates or gun enthusiasts who like their bump stocks and wanted to keep them. And one of the companies, the main company that made them and sold them, and said the rule is invalid because it was signed by someone who was illegally in the position of Attorney General. Now, Whitaker wasn't there for very long, and Attorney General Barr took over, and he ratified the rule retrospectively. And opponents said it's still illegal. Barr should have had to start that over. It seems like that argument is not getting much traction in the courts, but especially since Whitaker's appointment was upheld by courts in unrelated litigation to this. But I want you to be aware that we have rules like a regulation banning bump stocks for assault rifles, and then the president basically kind of ignoring the Vacancies Reform Act and putting someone else, the wrong person, as an attorney general, can then create legal challenges to the validity of a regulation that he signed off on. a lot more media attention and litigation surrounded Ken Cuccinelli, who was made the acting director of the United States Citizenship and Immigration Services, or USCIS. Cuccinelli did not really fit within an approved class for temporary appointment under the Vacancies Reform Act. President Trump had attempted to bypass the requirements by appointing Cuccinelli under a newly created, they basically created a brand new position after the head of the agency left that was called Principal Deputy Director. They just created a title and then appointed Cuccinelli to that so that he could then move directly into being an acting director of the Immigration Service. And but this somehow didn't really necessitate the dismissal of the Immigration Service, Mark Kuman. So there was someone else who was really the number 2 person at the agency that you would have expected to take over. They didn't really want to fire him, but they didn't want him to take over the agency. So they did this maneuver to put Ken Cuccinelli in the position. Now, Ken Cuccinelli had made some enemies in Congress. And so even though the Senate was controlled by the same party, there was as the president, it wasn't clear that this fellow would get confirmed by the Senate. He had made some enemies by backing primary challenges against some of the prominent Senate Republicans, and they had a grudge. That's the way the story goes. So Trump was trying to avoid having to go through a Senate confirmation process. And as you might imagine, advocacy groups for immigration advocacy groups challenged Cuccinelli's appointment in court, claiming that his asylum directives were illegitimate or shouldn't have the force of law because he lacked authority to serve as acting director of the department. And a U.S. District Court held that Cuccinelli was never eligible to become the acting immigration chief. And similarly, the Government Accounting Office, which it's actually their job to weigh in on issues like this and make sure orders of succession or chain of command is being followed. I'm sorry, the Government Accountability Office. They also held that his appointment as a senior official performing the duties of the deputy secretary was illegal. Now, I'm not going to go through all of these cases, but in case you are researching this or you're really interested in acting directors for a research topic, I just have a couple of slides that that show that we've had a lot of cases about this recently, and you may want to pause the slide and write down some of the sites if you want to look these up. We have a few cases about the National Labor Relations Board and people that were appointed, one from 2017. We have another case from the Ninth Circuit in 2016. This is Hooks v. Kitsap Tenant Support Services. And again, the court there held that Trump's appointee, it didn't fit within the Vacancies Reform Act. English v. Trump, which was a DC Circuit case in 2018 that found that that appointee was okay under the act. We have Bullock versus the Bureau of Land Management. This is very new from October 2020. I'm recording this in November of 2020. And this is about the Bureau of Land Management. And again, the director didn't satisfy, was not eligible for the position the courts held under the Vacancies Reform Act. We had a number of challenges to the acting director of Social Security, Barry Hill, but the courts, and we have an October case from a federal court in Iowa, the courts upheld that. And we've had a number of cases about the Director of Homeland Security, Acting Director Chad Wolf. And we have court decisions and GAO decisions going each way about the legality of Chad Wolf being in the position of the acting director of Homeland Security. But this case is from the DC Circuit, saying that he was validly appointed, but acknowledged that other courts had reached the contrary conclusion in recent weeks. And that concludes our somewhat tedious lecture about the Vacancies Reform Act.